In this video, my group will be presenting on the issues pertaining to the facts of the question and subsequently address it using principles by operation and derivative actions. The facts surrounding the internal dispute in Roda Sendiri Berhad give rise to two principal legal issues that are central to the operation of company law remedies under the Companies Act 2016. These issues concern number one, whether the majority shareholder Rahman can seek relief under Section 346 under the basis of shareholder oppression, and number two, whether he may commence directive proceeding under Section 347 for alleged mismanagement affecting the company itself.
When there is an oppressive act towards a member of a company, remedies can be pursued under Section 346 of the Companies Act 2016. There are two situations in which the courts can examine this. Firstly, in the affairs of the company, when there is an act towards a member and when there is powers exercised in an oppressive manner or in disregard of interest to one of the members or debenture holders. Secondly, in the situation when there is some resolution or proposed resolution in which debenture holders or a class of the members have passed or is still in the middle of proposal, which would unfairly discriminate or be prejudicial to one or more members of debenture holders. Taking into consideration a few cases that have established the principles of oppression, firstly in the case of Ree Kong Thai Sawmill, and whereby when there is a visible departure of standards of fair dealing that is expected out of shareholders, you can say that an act of oppression is present. Secondly, in a case of Pan Pacific Construction, whereby the theme of oppression is fairness expected out of a commercial relationship. So when this fairness that is expected out of a commercial relationship is not present, you can say that the principles of oppression has been established. In explaining whether some oppression actions could be taken into consideration of just and equitable refers to an agreement based on mutual understanding and legitimate expectations. There are times whereby shareholders may enforce legitimate expectations which do not arise from company structure, although this is subject to equitable considerations in the case of Ibrahimi. However, as enforced in the case of Jet Tech Materials, just and equitable could also equally apply to an oppression action, as whereby if these just and equitable agreements by some members of the company is prejudicial or is in disregards of interest to other members of the company, you can say that an oppression action is present.
In Rahman's case, he holds 60% of the shares in Roda Sendiri Berhad and was expressly named as the company's director in the articles of the association of the company with an annual salary of 200,000. It was clear that he would and should play an active and continuing role in the management of the company. This forms the basis of mutual understandings between the shareholders, giving rise to legitimate expectation regarding his role, remuneration, and involvement in the company's decision-making. However, after the conflict in August 2022, the exclusion of Rahman from board's meeting shows unfair and oppressive conduct under Section 346 of the Companies Act 2016. Rahman has not attended any board meetings since, and this exclusion was carried out without any formal resolutions which strongly suggest unfair treatment, especially when he remains as a director and the majority shareholder. This minority is trying to push him out of the company he legally owns. Moving on, by cutting off Rahman's salary, it is clear that there was a breach of the fairness and trust that shareholders expect, as per the case of Ree Kong Thai Sawmill and Lee Beng Soon, and the legitimate expectation for the case of Ibrahimi and Westbourne Galleries. While Razak and Nadia may argue that Rahman's assault on Razak justified their actions and any such misconduct should have been addressed through proper procedures such as board resolutions or shareholders meeting. Instead, what occurred was informal and in fact a removal of Rahman from his role in the company. The situation is serious by the fact that Rahman is the majority shareholder yet has been excluded by the minority from participating in the company he is the principal shareholder of. This creates a strong basis for him to claim under the oppression remedy in Section 346 of the Companies Act 2016. On top of that, this brings us to the next part of the discussion, whether Rahman may also pursue a derivative action under Section 347 of the Act.
A derivative action under Section 347 of the Companies Act 2016 allows a shareholder to sue on behalf of the company if wrongs are done to it and the company itself is unlikely to take action. It is a mechanism to enforce the company's rights when those in control, typically the directors, fail to act. It serves as an exception to the rule in Foss and Harbottle, enabling a shareholder to step in where the wrongdoers are in control and the company is effectively disabled from suing. Leave of court is required, and four key requirements must be met, which are good faith, a prima facie case, the company's inaction, and the action is in the company's best interest. The Malaysian courts have interpreted these requirements in several important cases. In Dato Seri Timur Shah Rafiq and Nautilus Tug and Tuwaj Sendiri Berhad, 2024, the federal court clarified that a derivative claim requires a twofold statutory hurdle: good faith and whether the action appears prima facie to be in the company's best interest. The court held that good faith involves both an honest belief in the company's claim and an objectively reasonable basis for that belief. It further emphasized that hostility between directors does not negate good faith if the intention is to protect the company's interests. For the best interest test, the court adopted a commercial perspective by focusing on whether the company stands to benefit financially from the action, without requiring a full evaluation of the claim's merits. Building upon this approach, the court in Wong Chin Yao and Sharikat Ong Yoke Lin Syndrome Berhat 2013 affirmed that a majority shareholder may bring a derivative action where directors in control are alleged wrongdoers. The court reinforced the principle that the law should not allow those in power to shield themselves from scrutiny by preventing the company from taking action. Section 347 introduces greater procedural clarity compared to the common law position, aligning Malaysia more closely with jurisdictions like Singapore and Australia, where statutory derivative actions are widely recognized as vital to shareholder protection. Derivative actions serve as an important check on management power, particularly in private companies, where directors and shareholders are often the same individuals, increasing the risk of abuse.
A derivative action is best defined as an action brought by a shareholder or director of a company in the name of or on behalf of the company in respect of a wrong done to the company, rather than to its shareholder. It is derivative as the party bringing in the action does not have the right to sue, but such a right is derived from that of the company. This action is usually done against an executive or a director. In the case of Rahman, we would advise he might be able to initiate a derivative proceeding. Although he is a shareholder, the rights to bring up a derivative action is reserved for minority shareholders. The case of United Engineer lays out that a shareholder with more than 50% of shares is considered a majority shareholder. Therefore, the action was struck down. Only a minority shareholder may bring in an action on behalf of himself or all the other shareholder of a company in a derivative action. The plaintiff, being the majority of shareholder, did not seem to fall within the contemplation of any of the exception to the rule of Foss against Harbottle. The case laid down an absolute rule that the action class is only applicable for minority shareholder. The rule laid out clearly that the applicant must have a prima facie case as well as the precedent that the derivative action is created in order to protect minority shareholders. Majority shareholders do not have a standing to bring upon derivative action due to the fact that there are alternative options such as having a general or board meeting. The court would avoid meddling with the issues that could be handled within the company and need not be brought to court. The majority rule is understood to be that issues and concern can be rectified by the majority shareholder in meetings and that the majority would overpower the minority shareholders. If these issues are able to be rectified in a meeting and need not be brought to the attention of the court will not interfere. This would give Rahman a major disadvantage as he is a major shareholder holding 60% of the shares and is considered the company's director. On this note, he can bring up the fact that the two other shareholders is making decisions without him and he is unable to reach an agreement with the other two minority shareholders. The power imbalance would give rise to his unjust position and the court may look into the derivative action in order to alleviate his concerns. Following the case in 2001, there was an appeal in 2018. In the same United Engineer Malaysia group Berhad, the federal court dismissed the case decided prior and stated that there was a valid grounds that the director of the minority shareholder is acting for his own benefit. Therefore, the action brought against him is valid. There was no mention of difference between major and minor shareholder, only that there was unjust enrichment and that needs to be handled and prioritized. Now that we established Rahman is a qualified party to bring up derivative action, the realistic step to take is to ask for a leave of court. In order for the court to grant a leave, we need to prove that he is acting in good faith and in the best interest of the company. In the case of Celcom, it laid out how elements may be satisfied. The Court of Appeal said the intention of the statutory derivative procedure is to enable a member, present or past, to seek leave to bring an action in the name of the company to recover losses sustained by that company. As such, leave to bring a derivative action must not be given lightly. There is a burden on Rahman's side to prove that he is acting in good faith so that the derivative action is not brought up just to take monetary or power advantage of the company. Rahman is truly being treated with unfairness and he is not looking to enrich himself unjustly. In the case of Celcom, the judge also take a look at other concurrent cases that might be concerning the parties involved. The test of good faith is twofold. One is an honest belief on the part of the applicant, and two, that the applicant for leave was not brought up for collateral purposes. As Rahman will not be privately taking action against the other shareholders or company itself, it will then be easily proven that he is acting on good faith. On the other hand, to prove that he is acting in the best interest of the company, we can take a look into the case of Abdurrahim bin Sulaiman and another against Farida binti Mod Lazim and others. The way to determine the best interest of the company is whether the company stands to receive any commercial or financial gain from the proposed action. In Rahman's case, the company is not gaining anything from the action brought up, so this would be an issue that would jeopardize Rahman's case. But we can take a look into decisions that Razak and Nadia made without Rahman's present in and decide if any loss was made. With that, Rahman could prove unjust enrichment or mishandlings of fund. Apart from that, we can take a look into a more indirect interest of the company. That is the harmony of the company and shareholders in order to ensure the best decisions are being made with the company in mind. By shunning him and selfishly keeping the decisions between Razak and Nadia, they're putting the company in jeopardy as Rahman is the director and acting head. This is not just unfair, but it would not be considering the company's best interest. Rahman's derivative action would help resolve the issue at hand and can help eliminate the other shareholders' suspicious behavior.
The possible outcomes under Operation Remedy is where Naza and Nadia's action of excluding Rahman from management and denying his remuneration without any formal board resolution or due process constitute oppressive conduct within the meaning of Section 346, which gives Rahman a strong legal opposition to seek relief. Now, the courts in Malaysia have affirmed that shareholder oppression may occur when directors act in a manner that is unfairly prejudicial, inequitable, or in disregard of legitimate expectations, especially in private or quasi-partnership companies. Now, in Re Kong Thai Sawmill versus Ling Beng Song, the Federal Court has affirmed that oppression entails a visible departure from fair dealing. Additionally, in Ibrahim versus Westburn, it was also acknowledged that shareholders may hold enforceable expectations to participate in management, particularly where the company structure is personal and closely held, as in Rahman's case. In his position, his exclusion from board meetings and unilateral salary termination constitute more than a breach of directorship. They reflect a breach of the mutual understanding and legitimate corporation expectations underpinning the company's internal governance. Therefore, it is proven above that there is oppression or disregard of Rahman's right. Therefore, again, a range of remedies may be ordered to Rahman by the court under Section 346 up to. A directive action under Section 347 of the Companies Act 2016 is considered an important role in building a better corporate governance, deterring directors from breaching their duties, holding directors accountable to their companies, and protecting the interests of the companies and shareholders. Based on our analysis, it has been established that Rahman has satisfied the statutory requirements under Section 348 sub 4, which entitles him to apply for leave to commence directive proceeding under Section 347. The case of Independent Oil Tools Malaysia Sdn Bhd versus Oil Resource Sdn Bhd has affirmed Rahman's position in commencing a directive action, where his intention for this was for the benefit of the company rather than the shareholder personally. His exclusion from the management of the company, coupled with the fact that he is a majority shareholder, shows that he does not stand to benefit personally beyond restoring proper governance and accountability in the company. His stated intention to lead the company into shape also reflects a genuine effort to act in the best interest of Roda Roda. Therefore, once leave is granted, he would then be entitled to bring proceeding under the directive action in the name of the company against Razak and Nadia for breach of fiduciary duties or any other misconduct as shown in Newell's Tech. Now, the remedies available may include recovery of company assets, reversal of transaction detrimental to the company, or orders to restore good governance.
Moving to recent case authorities, let's examine key rulings that support Rahman's potential claims. First, in terms of the oppression remedy, the 2024 case of Satyan versus Kaivi Lashini highlights that not all conflicts qualify as oppression. The case involves equal shareholders in a medical clinic. The plaintiff alleged oppression after being locked out of management, removed from company WhatsApp groups, and denied clinic access. However, courts dismissed the claim, ruling that marital disputes and managerial disagreements without evidence of commercial unfairness did not meet Section 346's threshold. This could parallel Rahman's situation, as he can be said to have been locked out of management due to Razak and Nadia intending to run the company without him, additionally not allowing Rahman to lead the company to shape. However, as his salary was stopped by Razak, despite his contractual entitlement, it can be said that it has fulfilled the evidence of commercial unfairness mentioned in the case of Pan Pacific Construction. Now, for derivative action, the affirmation case of Datuk Seri Timur Shah Rafiq is pivotal. The case shows courts will intervene if hostility among shareholders is against the protection of a company's interests. In this case, the company's decision has been clearly unsuccessful due to the omission of Rahman by Razak and Nadia. Additionally, the fact that Rahman wanted to make one last effort to, as I said before, lead the company to shape implies that the company has been dwindling ever since the omission. Based on the analysis, Rahman has a compelling case for relief under Section 346 for shareholder oppression, given his unjust exclusion from management and unilateral salary termination. While Razak and Nadia may cite Rahman's alleged misconduct as justification, their failure to follow proper procedures undermines their position, reinforcing Rahman's claim of oppressive treatment. Regarding derivative action under Section 347, Rahman's exclusion from decision-making and the company's best interests being disregarded prove a strong basis for leave to proceed, despite his majority status. Recent authorities further support Rahman's decision. Datuk Seri Timur demonstrates judicial willingness to intervene in cases of unjustified financial harm affecting a company's best interest, while Satyan confirms that commercial unfairness, such as the withholding of Rahman's salary, can substantiate an oppression claim. Notably, these decisions align with the framework proposed by Cheong and Lim in their analysis of shareholder remedies. Their analysis emphasizes that courts should examine the substantial fairness of corporate conduct rather than apply formalistic tests. In conclusion, Rahman should pursue both remedies. The oppression claim offers direct redress for his exclusion, while the derivative action ensures accountability for any misdirection of the company by Razak and Nadia. Courts are likely to grant relief given the clear breaches of corporate fairness and fiduciary duty in this case.